Hello, this is Kent Holland. This is a three-part series on site safety for construction projects. Now, the factors that the court in Herzog and other courts have looked at in determining whether to impose liability on a design professional are the following: whether there was actual supervision and control of the work, whether there was retention of the right to supervise and control, whether there was constant participation in ongoing construction activities, whether there was supervision and coordination of subcontractors, whether there was assumption of responsibility for safety practices, and whether there was authority to issue change orders and the right to stop the work. So those are factors. Now, it's not that any one or two of those necessarily is going to create liability, but the court looks at all these factors, and any combination of them might be enough to tilt the scale so that the design professional has liability. An architect was found liable to an airport maintenance man who was electrocuted while working on an electric switchgear box that had no warning labels. In this case, an employee of the airport was electrocuted while attempting to repair an electrical transformer that lacked a wiring diagram and also lacked warning signs. Now, the family of the deceased filed suit against the owner of the hotel, which was Hilton, as well as the architect that designed it, and the consultant that did the electrical engineering services, and the general contractor, and the electrical subcontractor, alleging that there was negligence, gross negligence, and breach of warranty. And this is a case of LeBlanc versus Logan Hilton. Now, the hotel filed cross claims against the architect and the electrical engineer, seeking indemnification and contribution. The Supreme Court of Massachusetts held that the claims for contribution were proper because the consultant owed an independent duty of care to the electrician to comply with its contractual obligations to protect the owner, to get the contractor to provide proper warning labels on the switchgear. The court said that failure to notify Hilton of the manufacturer's failure to install the warning signage constituted a contractual breach that posed a, quote, field of risk for third parties likely to come into contact with the switchgear, and summary judgment should not have been granted since there was an issue of fact of causal negligence to be decided by trial, close quote. In this case, the first point the court made was that it, quote, is settled that a claim in tort may arise from a contractual relationship and may be available to persons who are not parties to the contract, close quote. What happened in this case is that the engineer actually knew that the contractor had not met the specifications by installing the warning signs and the diagram showing how the wiring went. And what happened was the engineer reported that to the contractor and to the owner and said, you know, this needs to be corrected. So it was all documented, but for some reason it fell between the cracks. And even though there was back and forth several times on this needs to be accomplished, it never got accomplished, and ultimately the job finished up. The punch list was approved even though this was never corrected, and the court said that in allowing that to happen, that the engineer had failed in its contractual duty that it owed to the owner, and that at the same time it owed an independent duty to these third-party individuals, the individual who was killed as a result, because that contractual breach actually led to the negligence against the deceased individual. A design professional case that actually has bearing on construction managers and contractors and even project owners is one that deals with third-party claims against the designer for injuries. And the injuries were concerning mold inhalation. So an environmental consultant was working for an insurance carrier to do certain work with regard to resolution of fire damage and water in the house. And the consultant was under contract to this insurance company, and it found that there was mold in the house, and it reported it to its client, the insurance company. But the consultant did not warn certain contractors that were working for the homeowner doing, we'll call it the renovation or remodeling work as a result of this fire damage and the water damage. They didn't tell the contractors about the mold that they had discovered in the house, or about the risks that that mold could pose to them. Several employees of the contractor filed suit against the consultant, alleging that they had personal injuries due to the mold exposure. The court dismissed the suit, saying that the consultant performed its work, discharged its duty to its own client, and it owed no separate duty to the homeowner or to any of the individual employees working for a contractor for that homeowner, since there was, quote, no legal relationship or privity of contract between the parties, and the consultant did not possess control of the premises, close quote. Let's talk about construction manager site safety. This would be where the construction manager is not necessarily at risk, perhaps as an agency relationship with the project owner, and there is a construction contractor on the project. What responsibility does a construction manager have? A construction manager agency relationship with the owner was found to not have responsibility for the injury of an employee that a contractor's employee sustained to his eye when a clamp that he was loosening on a clogged concrete pumping pipe exploded into his face. He sued the agency CM, who was in contract with the project owner and had no privity of contract with the contractor. The CM was found to have no liability because it had no supervisory control or authority over the work, and it did not create the actual dangerous condition and did not have actual or constructive knowledge of that condition. The CM did not provide labor or material to the contractor, and it didn't direct the employees of the contractor in how to perform their work. The court concluded that the CM contract specifically withheld from the CM any authority to control either the contractor's work, its materials, or its safety programs. This is the case of Shawn Adair versus BBL. Another construction manager case involving, once again, another pressurized concrete delivery pipe concerns an employee of a sub that was injured when the pressurized concrete pipe whipped around and caused him to fall. He sued the construction manager for negligent supervision of the work. The court held in this case that the CM should have been granted summary judgment and the case dismissed against the CM because where a claim is based on defects or dangers in the subcontractor's means, methods, materials, then the liability can't be imposed on the CM absent evidence that it actually exercised supervisory control. To do that, the court said, quote, it must be demonstrated that the contractor controlled the manner in which the plaintiff performed his work. Period, close quote. Here, the CM had employed a firm named Site Safety Inc. to comply with the New York Administrative Code requirements, but its role was limited to performing safety-related tasks, and it didn't have the authority to control the manner in which the work was performed, and it didn't actually take any actions to control the subcontractor's work. So the fact that the CM and Site Safety Inc. both had authority to stop the work for safety reasons was found by the court not to be sufficient evidence of supervision and control of the subcontractor's work. Therefore, subcontractor alone had the liability for that employee's injuries. This is a case of Hughes versus Tishman Construction. In determining what safety responsibilities either a designer or a construction manager might have for employees other than its own, a court is going to look at the contract in the first instance to see what the firm agreed to. And for example, in this next case called Farball versus Pennsylvania Turnpike Commission, a general contractor's employee was killed while driving a dump truck on a construction site that was owned by the Pennsylvania Turnpike Commission. It sued the Turnpike and the CM that was under contract to the Turnpike. And the court refused to grant summary judgment in this case. The court really also refused to establish a standard rule as to what the CM responsibility for safety would be, but instead said you must always look at the contract. And the court found that the role of the CM is much more like that of a design professional than it is of a general contractor. However, in this case, the court looked at the contract and said, look, this contract requires that the CM develop a safety plan, monitor the contractor compliance with the safety regulations on a frequent and regular basis, and plus it had the authority to actually stop the work. And for these reasons, the court did not grant summary judgment, and it said the case had to go to trial on its merits. Now, you're going to notice how that case is at odds with other cases that we're going to be talking about in this module of site safety videos, where other courts have looked at it and said just because the CM had the ability or responsibility for reporting to its project owner what was happening with regard to site safety or attending meetings, etc., or writing reports, didn't make the CM responsible. So you see the variety in judgments that you can have. But also notice here that the court is really going to focus in on the contract, and in this case there was authority to stop the work. And this is one of the things that when I'm looking at contracts, I don't like to have the authority to stop the work. I would rather that the CM and the design professional have the responsibility to, let's say they have the authority to recommend to the owner that the owner stop the work. We might have the authority to reject work, but not to literally stop the work. That should be something where we advise the owner that in our judgment the work should be stopped. It takes it one step removed from what the court was able to do in this instance by saying because the CM had the authority to stop the work, that the CM might somehow be found by a jury to be responsible for the unsafe work itself. In this next case, we're going to address where a construction manager was found to have no responsibility for job site safety. And it's such an interesting case and covers so many interesting different aspects that I'm going to really talk about this at length. And I'll put up quite a few slides where we have quotes from what the court said in its holding. So this is a case of Hunt Construction versus Garrett, and an employee of a concrete contractor, Baker Construction, actually was injured in a workplace during construction of a stadium. While removing forming material from concrete, one of her coworkers dropped a piece of wood that struck her on the head and on the hand. And although employed by Baker, she actually sought to recover from the CM, Hunt Construction. And she alleged that the CM had a legal duty to care for job site employee safety. Now, you have to understand the context here. This employee would have received her workers' compensation from her employer, the contractor, but once more. Well, you can't get more from your employer because of the workers' compensation bar against recovery of more than just simply what's allowable under workers' comp. So instead, she goes after either the project owner or the construction manager. And if she can recover from them, it could be millions of dollars. And so that's the attempt that you see consistently in cases where parties are injured and they seek a way, not always but often, to go beyond what workers' comp allows and to get additional compensation from other parties. Now in this case, the court said that the CM's only contract was with the project owner and it had no contractual relationship with Baker Concrete or any other contractors on the project, no direct relationship with the injured laborer. In deciding whether the CM owes a duty, the court explained that it focuses on determining, quote, whether such a duty was imposed upon the CM by a contract to which it was a party, and secondly, whether the CM assumed such a duty either gratuitously or voluntarily, close quote. Now the court found that there was no legal duty of care for job site employee safety. It hadn't been imposed by contract on the CM. And the court said, quote, first, the CM contract itself did not specify that the CM had any responsibility for safety whatsoever. Second, counterpart construction contracts signed by the contractors and subcontractors indicated that they had responsibility for project safety and the safety of their employees. Third, those contracts expressly disclaimed any direct or indirect responsibility on the part of the construction manager for project safety. Close quote. The court also found the following, quote, none of the safety provisions in the CM contract here impose upon Hunt any specific legal duty or responsibility for the safety of all employees of the construction site. In fact, the court said that the contract supports the opposite conclusion, and the court said the following, quote, Hunt's contract expressly states that its CM services are to be rendered solely for the benefit of the client and not for the benefit of the contractors, the architect, or other parties performing work or services with respect to the project. Moreover, the contract provided that Hunt was not assuming the safety obligations and responsibilities of individual contractors, and that Hunt was not to have control over or charge of or be responsible for safety precautions and programs in connection with the work of each of the contractors, since these are the contractor's responsibilities. In short, Hunt did not undertake in its contract a duty to act as the insurer of safety for everyone on the project. Rather, Hunt's responsibilities were owed only to the client, not to workers. It's important to note that the court here was critical of what it called the plaintiff's all-or-nothing proposition, that by virtue of agreeing to certain safety items in its contract with the owner, the CM had somehow become responsible for all job site safety, including that which pertained to the employees of contractors. If that argument were accepted, said the court, then CMs would be made liable in situations like this one, and that would actually be bad for job site safety. The way the court explained its reasoning is as follows, quote, safety at construction sites, especially at large public works projects like this one, should not be sacrificed for fear of exposure to liability. The contract at issue here reflects a way of promoting safety without exposing construction managers to suits like this one. The position advanced by claimant would make it virtually impossible for a contractor taking on the role of construction manager to limit its liability so as not to become an insurer of safety for workers of other contractors. Period. Close quote. So in this case, even though the CM participated in site safety meetings, issued site safety reports, and did other safety-related activities, the court found that all of these were within the scope of the contractually agreed-upon services that were performed strictly for the benefit of the owner-client and not for the benefit of employees of any contractors. This seems to be the key in many of these decisions in which the contract and the actions in the field demonstrate that the CM was only serving the interest of its client and not anyone else. And so that is the focus of the court, is to determine, was the CM acting for its client, or did the CM have somehow either a contractual obligation or by its actions in the field insinuated itself into responsibility for the actions of a contractor or subcontractor and the injuries to their employees. In talking about site safety, one of the things I really emphasize is the importance of discussing this with attorneys in your particular state familiar with the laws concerning site safety. It really varies a lot from state to state. This has been just a general educational presentation for general risk management purposes to give you some oversight, an overview of the whole issue, but it is by no means legal advice, and I really encourage you to seek legal advice in your particular state on all of these issues. My contact information is on the last slide that I'll put up at the end of this program today, with my email, my phone number, etc. Again, I'm Kent Holland with Construction Risk LLC, and I appreciate the time that you've spent with me today.